Hello, everyone. My name is Ariella Wagner. I'm the founder of SunRay Construction Solutions. We help thousands of general contractors, subcontractors, and suppliers secure their lien and bond claim rights. Today, we have our last webinar of 2022, the Tennessee Prompt Payment Act, Reasonable Assurances in Stopping Work. So without further ado, I introduce the fabulous Bryan Thomas.
Ariella, thank you. Thank you. Ready to close out 2021 here. Hopefully you guys are as well. Today is, let's see, number one, if you've got questions, let us know. Glad to answer them on the webinar, or glad to answer after. This is the last of our 10-part series for 2021. Be on the lookout for 2022. We are going to do a couple things in 2022 as well. If you enjoyed these, hopefully we'll give you some more topics that are of interest and useful to each of you guys. With that, wanted to give really the quick summary of where we've been in the 10-part series, which is what does the Tennessee lien law look like? And generally speaking, we've been through a lot of things, but in Tennessee, we've got prime contractors and remote contractors. And those are the two divisions for our lien law. The work, which can be lienable, is really anything that is improving the property itself. And the property can be the fee simple interest in it, or it can be a leasehold interest, or it could be even a common interest under the horizontal property regime. So for how much? Well, you can lien the contract price and extras, but you can't lien for interest and attorney's fees. So big picture, that's our lien law in Tennessee. For a prime contractor to perfect their lien rights, they have to file suit within 1 year. To protect their priority, they also need to record a notice of lien in the chain of title within 90 days of completion or abandonment. For remote contractors, we've got the additional requirement and a little bit different timing sequence. Number one, we've got the notice of non-payment. It's a rolling requirement, 90 days after the end of the month in which the services or work were performed. You've got to send a notice. After the notice, assuming you preserved your rights, then we've got the notice of a lien. That is what has to be recorded in the chain of title within 90 days of completion or abandonment. Unlike primes, remotes have to do it. And at the end of the day, the remote contractor also has to perfect the lien by filing a lawsuit and issuing an attachment within 90 days of recording the notice of lien. Big picture, that's where we've been. We've dove into a lot of details along the way. Now, to close the series out, we wanted to talk about the Corollary Act, which would be the Tennessee Prompt Payment Act, in as far as protecting payment rights. First, I'm going to tell you, generally speaking, the Prompt Payment Act has a couple tools and had a couple tools. We got to some amendments in 2020, which I'll talk about in the next slide. Historically, we've had retainage requirements, and retainage requirements, that could be a whole webinar on its own. In general, retainage has to be deposited at the time it's withheld in an interest-bearing escrow account, and the failure to do so is subject to $300 a day. That's a whole different animal, but one we can probably talk about in a future webinar. There's also the trust requirement, meaning that as soon as money is committed and starts flowing through the process of lender to owner, owner GC to remote to further remote, once that starts flowing, those funds to be held in trust to make sure it makes it all the way down the line. That's useful in some payment situations. Our Prompt Payment Act also has timing requirements as far as when payment is due. That said, it is subject to what is in the contract between the parties. So generally speaking, the contract is going to govern over the Prompt Payment Act. At least that is the general thought. Our Prompt Payment Act does allow contingent payment clauses, both pay when and pay if paid clauses. So if those are in the contract, they are likely going to be enforceable in some form or fashion, depending exactly how they're written. All right, so our teeth are pretty limited in the sense of, well, the retainage has some pretty strong teeth. And again, that's an animal of its own, $300 a day. The remainder, just failure to pay contract balance, we used to have a minimal interest, and then we had the potential to collect attorney's fees if payment was not being made in good faith, or said differently, if the withholding was in bad faith. That's a pretty high standard and really hard to get to. So as part of the 2020 legislation where the construction industry in Tennessee came together, one of the things we fixed was teeth. And now the Prompt Payment Act has 1.5% interest per month as the real teeth to encourage prompt payment and penalize bad behavior. The attorney's fees portion of that stayed the same. You still got to have bad faith, but the thought is the increased interest will encourage the behavior we need. It also added a user-friendly, statutorily approved lien forms. You will see some of those from SunRay as well. Those are very useful to make sure that folks in the industry can get to those forms and get those forms sent out and on file to preserve their lien rights without having to necessarily go to an attorney. So the two big sort of new aspects to the Prompt Payment Act that we're adding in 2020 that we're going to dive into today are the right to stop work and the demand for reasonable insurances. I've got in this slide the real highlights and the takeaways from those. And the stop work procedure is essentially codifying what was already there at common law, and it's more of codifying a procedure than a right. And we've got to make sure that people are aware of that. And by that, I mean, there's not an absolute right to stop work unless there is a lack of response from the party whom you are owed money. And we'll dive into that a little bit here in a minute. On the demand for reasonable assurances, it's an additional tool as the industry talked on how to develop the construction statutes, and the problems and the real payment problems seem to stem more from projects where sole source entities or project entities and the project financing dried up. Because of that, one of the things that was explored was really, okay, how do we give primes all the way through remotes some assurance that the money will be there at the end of the day, or there's funding. It's part of that. We have the new section of the statute on reasonable assurances. We'll get to that in a little bit more detail in a minute. All right, so let's start with the old portion of the Prompt Payment Act, which is how do you actually trigger it? And the answer is you trigger it with a demand. It's a demand letter. That letter can be sent by a number of means. The key is you just have to have written confirmation of delivery. What that does is it starts a period in which the other party has to respond within 10 days, stating, quote, adequate legal reasons. Now, I have that highlighted in blue because that is the key to our Prompt Payment Act. And we do not have case law saying what adequate legal reasons are. Most practitioners or construction lawyers in Tennessee believe that is probably going to be interpreted as a material breach standard. It's open, it's questionable, but that's what we have in the statutes. So the demand, there's a form, SunRay has it. You can send that demand, triggering the 10-day response period. And if you don't get a response, a lack of response itself is a violation. If you get a response, then you've got to decide whether that response, quote, has adequate legal reasons for the withholding. So that's where we are as far as the Prompt Payment Act demand, and nothing changed there in 2020. What did change is there's this new inclusion of what a Prompt Payment Act demand looks like. And again, SunRay's got some versions of these as well. This makes it so, in theory, lieners don't need to go to a lawyer at the very front end to protect their payment rights. That's always subject to, the size of the lien and the complexity, but that is the idea behind the new form. Now, on top of that, we've got these new sections. And the section B that I'm going to go through in the next 2 or 3 slides is the new section on the stop work order. Okay, so we've got a separate section, B1, for payments to the prime, and B2 for payments to the remote contractor. And again, the key here is this gives you a procedural mechanism to stop work if the party above you has not made payment or furnished a response. So it's triggered with your Prompt Payment Act notice, and then is only triggered if you don't receive a response setting forth, again, you'll see the blue highlighted phrase again, adequate legal reasons. So that's really the trigger. And because of that, there is still some uncertainty in the industry, again, what adequate legal reasons are, and some apprehension about what a court is going to do with those words. And there is some concern that some claiming party may misinterpret the statute and go ahead and see it as a firm right to stop work, period, which can lead to what we call the nuclear situation, in which claims and damages get very big very quickly. So I caution you, we do now have this tool, but the tool is a tool to be used with care, because it still is going to interpret that term adequate legal reasons. That's where we are with the new tool. The other new tool we have is the reasonable assurance tool. The reasonable assurance tool is two bites to the apple. One is before anything starts, a prime contractor, no, this is not remote, just a prime, has the right to go in and request reasonable assurances from the owner. And this is to really make sure that everyone in the process is protected, not to bombard an owner who is trying to get financing with requests from every potential remote contractor on the project. Now, the key for people that are probably listening to this webinar is the second, which is once you're in a project and you see there is payment issues and you wonder whether it's a funding issue or whether it's something else, you now have the tool, regardless if you're a prime or a remote, to send a new request for reasonable assurances. Now, the key to this one is the second one actually has some more teeth. The first one, this A1, is really something to reference for a prime contractor when they want to get into an owner's financing before inking a contract. The second is really a tool to be used when payment becomes an issue. Now, and again, there's a new form for this reasonable assurance. I've used a couple different colorings here to highlight the fact that this notice for reasonable assurance can expressly be sent with any of the other notices that we have talked about. The notice of non-payment that we talked about for remote contractors and lien, the notice pursuant to that 6634-602, that's the Prompt Payment Act notice that we looked at a couple slides before, or any other notice. So it can be sent with a notice of lien itself, if a remote or a prime is reporting a notice of lien and serving it on the owner or the prime as applicable. So it can be sent with anything else. And again, there's a form, SunRay has these as well, that will get you where you need to be as far as making sure you have triggered the request for reasonable assurances. Now, what is the teeth in this? The teeth is this. The teeth is similar to the Prompt Payment Act notice. The owner has 10 days to provide a response. One, explaining what the terms of the financial arrangements are, or explaining the adequate legal reasons for the owner's failure to make payment. So it's one of those two things. Usually it's, if funding is not a problem and it's truly a contractual dispute, you're going to get B. If funding is a problem, or they're having to refinance, which is essentially what we saw in a lot of the cases when the industry met as far as being problem projects, you're going to get some assurances back from the owner of the new financial conditions, or potentially old. Once the owner does that, they are then locked into the situation that they can't materially vary those financial terms until giving notice to all the primes and the remotes who have asked. So that is a leverage point for anybody that is owed money on a project. So this new reasonable assurances at least tries to knock out the concept of whether money is available to be paid, setting aside if there is a contractual fight or arguments to be had about whether the money is due. All right, so that is what we have for today. Again, short discussion of our Prompt Payment Act, the two new tools in it being the right stop work, or really the procedure to stop work more than right stop work, and the request for reasonable assurances. With that, I will open up the floor and see if there are any questions. And the other thing I would encourage is that anybody has topics they would like to hear about Tennessee law, please send an email to Ariel or me, and we'll be glad to try to address that in the upcoming webinars in 2022. Otherwise, Ariel, do you have anything else?
You know what? There aren't any other questions, and no. So you did a brilliant job yet again. And if someone does have a question that they think of after this webinar, again, please feel free to send an email to us at any time. And a happy and healthy, well, first, a very Merry Christmas and a happy and healthy New Year to everyone. And we'll see you in 2022. And thank you so much, Bryan.
Thank you. Thank everyone out there.
Bye-bye.